So, good morning, students. So today we are going to do the topic for general defenses in torts, and we have already focused on certain aspects in our previous classes relating to concept of tort, relating to how it developed, and what are the objectives and purposes behind the law of tort, and what are the basic constituents of tort, where we have studied about injurious and denums and injuria, and we have seen what is the difference between the law of tort and that of the contract. So when we talk about law of tort, it is a subject, or you can say it's an area that motivates people. I've already stated this thing, that the object is to ensure that people are adhering to certain standards and obligations that are there, right? That exist when we are talking about rights and duties. That there is always certain rights, and if you have a duty, then there are certain rights of other party, and you're infringing by not performing your duties. You are infringing these legal rights. So when we are saying that there is violation of legal rights, there is infringement of legal rights, we say that plaintiff gets an opportunity, plaintiff, not an opportunity, but yes, a remedy to bring an action against defendant for a particular tort that has been committed against him, where there is violation of legal rights that has resulted in legal damages. And here, when we talk about the claiming or compensation, in that case, it is required that the plaintiff should prove that the essentials of torts have existed. Right? What were the essentials? That there should be some non-performance of duty, the duty is imposed by law, there is some damages that has been inflicted, and there is some remedy that existed, because if where there is right, where we have a remedy. So for every these essentials, when we say that yes, essentials have been fulfilled, in that case we say that yes, you can bring an action for violation of your legal right. And in these cases, the defendant is held liable for infringement of your legal rights. But there are few exceptions, you can say. There are few situations where the defendant can plead that the wrong has not been done, or the wrong that has been done was done under certain situations and circumstances. These exceptions works as defense for the defendant, which helps him in absolving from the liabilities with which he is being accused with, right? So we are saying that in law, it's not that only the rights of the person who is a victim is are protected, but yes, if a person is accused of a crime, the rights of that person, that accused person, are also protected, and that person is given an opportunity to defend himself or herself. So when we are talking about these defenses, what comes to your mind? That what is this? It's the part of fair procedure. It's the part of a principle of natural justice, that no party should be left unheard, and there should be proper procedure that should be followed. Why? The purpose is to strike a balance between the rights of both the parties. So these immunities that are provided to people, there is a purpose behind it. There is the purpose being that even the accused should also be given a right, an opportunity to defend himself or herself, and to place before the court of law his or her own case. So we are saying that these immunities, these defenses, exceptions, there are certain exceptions under law of tort, under which a defendant can claim that yes, the wrong that has been done by him is not entirely his fault, his or her fault, or there has been some a mistake from the other party also, or the situation was such that person could not have avoided the happening of an event, right? So we say that these exceptions are or defenses are general and applicable to many of the torts, okay, but they are not all. They list, it means that the list is not exhaustive. You can include other also, where you are claiming a particular aspect. There are other defenses too, which are peculiar to particular wrongs, and they have been dealt with their appropriate places. So it depends upon the case to case that which what defense is required. According to that particular situation, you apply your defenses. You plead to court that yes, the offense for which you have been booked has not been committed by you, or if it has been committed, then there are certain other situations connected with it. So what are the general defenses in tort? When we talk about general defenses, we say that where the plaintiff himself is a wrongdoer, defendant can say this. Private defense can be a defense. Necessity, defense of necessity. We will deal with all these defenses. Inevitable accident is there. Vis major, that is act of God, because of any unavoidable circumstances or event which is counted under act of God, you were not able to protect the plaintiff. Mistake, statutory authority, and voluntary non-fit injuria. So when we talk about this, first we'll come to the concept of voluntary non-fit injuria. Now, when we talk about voluntary non-fit injuria, we say that if it's that concept, that maxim which says that if plaintiff has consented to a wrongful act, and that consent is a free consent, and consent can be expressed, it can be implied, then voluntarily, if the plaintiff has accepted the risk, then plaintiff will not have any right to sue the defendant. And there is a duty on behalf of others to ensure at the same time, when we are saying that a person is not be liable the defendant, but at the same time the defendant will also be making sure that due care has been taken by the defendant. We always see both the sides of the parties when we are dealing with a particular case. So I'll explain it to you what it means. Like for example, if you are going for an adventure sport of bungee jumping, let's say, now the person who is under the duty to make sure that you have been tied properly has not performed his or her duty, then in that case, who will be liable? It will be defendant. Though plaintiff has given the consent, but at the same time, defendant also has duty to ensure that whatever services they are providing, they are up to the satisfaction that yes, they are providing proper services to the plaintiff. So we say that yes, in voluntary non-fit injury, it is one of the ground where defendant can say that yes, there is no damage that has been caused because of his or her fault. That is there, and in that case, what happens? The burden of proof is on the plaintiff to it is on the defendant to prove that there was free consent from plaintiff. The plaintiff had the knowledge about the risk that is involved, and the consent that has been given is free. It is free from any fraud, coercion. There is no undue influence under which the consent has been given. So what it says, what voluntary non-fit injuria says, it says that one consent is a good defense against oneself. So it says that this consent that is being given by plaintiff, it will be a good defense against me. Me means I am the defendant. So it will be a good defense for me to say this, that the plaintiff has given the consent. So to a willing person, no injury is done, or no injury is done to a person who consents, is a common law doctrine. So which means that if someone willingly places themselves in a position where harm might result, knowing that some degree of harm might result, they cannot then sue if harm actually results. Is it clear? This is what this principle says. But when we talk about this principle, we talk about two basic things in this. What is this? I will come to this. So what is this principle talking about? It is saying that there is the person has waived off, right, had abandoned the to accept the risk that is likely to happen. So we say that what is it when we talk about the consent, it is said that it should be a free consent. It should be the free consent on the part of the plaintiff, and that the plaintiff had the knowledge, not because knowledge itself, when we say that there is knowledge but there is no free consent, then in that case defendant cannot then defendant will cannot take the defense of voluntary non-fit injuria. This knowledge and free consent should go hand in hand. It means that if I have a knowledge that yes, there is a risk, but I do not have free consent, then in that case, defendant cannot say that there was knowledge and the person has, and there is some kind of pressure on the plaintiff to go for a particular act that included risk. So defendant cannot say that there was the knowledge and the consent both. But what is to be taken into consideration is that there is a free consent. Along with this free consent, there is knowledge. So both these essentials have to be taken together in order to decide whether defendant will have the defense of voluntary non-fit injuria or not. And please make sure that if in case these are the maxims that are there. So you should know that what these legal maxims mean. So I will request all of you to keep these legal maxims in mind, that is there. Okay, is it gone? One second. Huh? Yes. So these legal maxims you should know relating to voluntary non-fit injuria. You should know it's a Latin maxim. Okay, and the scienti non-fit injuria, which means only knowledge of the risk is not enough to claim defense. There should be some acceptance to undergo the risk that has been consented to. Okay, so what we are saying that in voluntary non-fit injuria, we are saying that no action lies against the injury suffered voluntarily, as no man can enforce a right which he has voluntarily waived off or abandoned. The consent can be expressed or implied, as I've already stated. One cannot sue a guest for the trespass when one has invited himself. Like for example, I would like to give an example. Like for example, if I have invited a guest, I cannot sue that guest for trespassing my property. Similarly, if there is a boxer who has consented to being hit, then the injuries that are suffered, the boxer cannot bring an action. But what is the condition to it? The condition is that whenever a player is playing a particular sport, then in that case, it is important that they are following the rules of that particular sport also. So punching outside the usual terms of boxing can bring an action against the defendant. So long as you are following the rules of a particular game, you will not be booked for any kind of damages if any injury suffered, because in this case there is a consent, there is a knowledge also. The consent is also free, and the knowledge is also there that if this particular game will be played, then what will be the result, right? So punching should be done, but within the terms of a particular game. So you need to understand that yes, if we are saying that yes, defense is available, then to what extent that defense is available. So even when we talk about this, we say that yes, there is a defense, but within that defense there are certain exceptions. And what are these exceptions? Exceptions means that when this defense will not be applicable. Is it clear? So we cannot say that in all the situations the defense of voluntary non-fit injuria will fit within. It will depend upon the situation, that whether there were any other exceptions to it. To what extent we can say that yes, the defense can be applicable. So exceptions like for example illegal consent, we'll discuss. The consent is illegal, there is negligence when we have rescue cases, right? So we are saying that where we are saying that yes, there are two main essentials of consent and knowledge. We also say that it is under certain exceptions also to say that the defense of voluntary non-fit injuria exists. Is it clear? So these are the two defenses when we are saying. So it should be. This is what I've already discussed with you, explained you. So, like for example, we'll come to the exceptions also, but first let's just take up few cases that are important in this. So there is this case of Hall versus Brookland Auto Racing Club. Now this is a case where during a car race, the spectator got injured due to the collision between two cars. Now during the collision, one car, he got injured? During the collision, one car came into the stand that caused injury to the plaintiff. Now plaintiff sued the defendant for damages, but in this case, court held that defendants are not liable to pay damages as the plaintiff has himself took the risk of injury. Now, you as a spectator, whenever you're going for cricket match, similarly applies for the cricket match also. So if you go for as spectator for any game, if you have gone through the rules of game or if you must have seen the ticket, you will see that there are certain clauses that are given in that these particular rules that specify that these things can happen, and then you cannot bring an action against a particular authority or an organization, because you know that when if you are going to, let's say, going to watch a horse race or car race or any game where you're going, so as a spectator you are taking that risk. You know, you have given the consent by paying for the tickets. What have you done? You have given your consent, you have taken ticket in your name, it means it's a consent. And it also includes that there is a knowledge that yes, if you're going to be there, anything can happen in the auditorium or while the game is on. So we are saying that in this case, the defendants can be saved by taking the defense of quality non-fit injuria. Now there is another case that deals with this aspect, right? This is Padmavati versus Joganayak case, which is there, and which is a jeep accident case. Okay. Now this is a case that deals with the situation where the master has directed his servant to get the car filled with petrol from the nearby petrol pump. Now, what happened? The servant on the way, while going on the way to petrol pump, given lift to two people, and who have asked for the ride from him. And as a result, what happened? They met with an accident. Now, the question came up before the court that who will be liable? Is it the employer who will be liable? Is it the driver? Is it the rider? Now, this is a question that need to be given a thought. Why? Because when we are talking about the liability of employer, driver, rider, there are three things that you should keep in mind here. One is the concept of vicarious liability. Second is the concept of voluntary non-fit injury. And the third one that we can talk about here is relating to negligence, right? So when we are talking about these three aspects, when we say that employer is whether employer will be liable to the driver or not, act of driver or not, and whether both of them will be available or will be liable or not. And there is another aspect to this, that is the concept of inevitable accident, right? So this is a case where all the three parties have taken their own case. The riders have said that it was an inevitable accident, and further for the act of for the negligence of driver, the employer will be liable. Employer has taken the defense that it is something where I'm not liable because I had no knowledge. The concept of vicarious liability will not be applicable because it was not as per my directions. It was outside the course of employment, right? This is not something that happened on my direction. It was not an order that was given by me, so I should be exempted. Now the driver says that I was working within the course of employment, and that it is an inevitable accident. So what will happen? The driver and the family will make a compensation, can claim a compensation for employer. Riders can claim a compensation for employer and driver. So the question that is there was very complicated as to whose right will exist and what is it that will be taken into consideration. So while deciding, court said that yes, it's a case of inevitable accident, right? But it's not a case for vicarious liability. Employer will not be liable, considering that it is not something which was directed by employer. It was within the course of employment, but it is not something which is being given as direction by the employer. Employer had no knowledge of the act of driver, right? And therefore employee will also not be liable to pay compensation to driver or riders. So court said, and what happened, they said that and what further plea was taken up by employer and driver. Here we can say that yes, driver has also taken up, that is voluntary, that these riders have voluntarily given their consent. It is not that that if a driver will say that what is the defense that is available to driver will say that what is it? It is voluntary case of voluntary non-fitting. It's a defense for me because these two riders have given their consent. They have complete knowledge of this aspect. So it was said that plaintiff, that is jeep driver, along with two strangers in the jeep, were traveling, and this is the fact that is there. What was held by the court is neither the driver nor his master could be made liable. First, because it was a case of sheer accident, and secondly, the strangers had voluntarily got into the jeep, and as such, the principle of voluntary non-fit injuria will be applicable. Now they have said that yes, the accident that happened, that was an inevitable accident. That one cannot foresee, but when you are taking a ride, you can probably say that something wrong can happen. There is a probability of the same. So you cannot say that a driver or his master were at fault because you yourself have given consent to a particular event to for this aspect of giving taking the ride or taking lift from a person. So when you're doing such act, you will be liable for your own act. So this is the case which is talking about one case that talks about voluntary non-fit injuria. Now I would like you to just come up with the doubts. Okay.